Okay, guys, so the first thing we need to talk about as we move into the civil rights movement is the landmark case of Brown versus Board of Education. Part of what's been happening as kind of like the Cold War is taking shape and Americans are prospering, is that African Americans are beginning to challenge segregation laws throughout the United States. And in some cases, the NAACP is right there to help them sort of challenge that and test the laws through the court system, right? So that's how they do it. They want to fight segregation. They want to fight Jim Crow laws by using the courts, right? This is one of the most active sort of periods for, challenging a lot of this segregation laws that were created in the wake of the Civil War in the South. And really, it's not just in the South. There's a lot of segregation all over the United States as well. But we are going to sort of focus on what's happening in Topeka, Kansas in 1954. Okay, so school segregation was a matter of fact. I mean, that's the way that it was in most places throughout the country. It was seen as normal and everyday, absolutely nothing wrong with it, as far as, some people could see in terms of the law, right? But it's going to be questioned more and more by Black folks. Is this right? Having to be bused, long distances to go to school and all of that. And so the NAACP here is going to adopt this strategy where they're going to start to begin to challenge these laws or challenge the way that it is by suing school districts and suing cities and governments. And essentially what they want to do is they want to get a law in the books that says that segregation is illegal. Okay? So I want to show you guys a part of a video here so you can get a better understanding of why this case is so important. It is going to overturn Plessy v. Ferguson, which had been matter of fact since 1896, right? So remember, we're going way back to the beginning of this semester. We're almost kind of coming full circle when it comes to segregation laws and equal rights and protection under the law. But watch this video for the next couple minutes and then we'll resume our lecture in a bit.
By the early 50s, segregation was frayed by the war and torn in spots where the court had acted. The white primary was outlawed. Housing covenants outlawed. Some graduate and law schools were forced to admit blacks. But the court was aware that the big fight was still to come. The schools, K through 12, white children and black in the same classroom.
Southerners assumed that if grade school kids were in a desegregated setting, they'd get to know each other and they'd get to date each other and then they'd marry each other. And that was the strongest taboo that the South held.
Led by Thurgood Marshall and other young lawyers like Robert Carter, the NAACP Legal Defense Fund was running or aiding cases all over the country. The court picked 5 and consolidated them into one set of arguments, forever known as Brown versus Board of Education of Topeka, Kansas. As oral arguments approached, people camped outside the building to assure themselves a seat in the courtroom. NAACP lawyers Marshall and Carter were up against a formidable adversary, John W. Davis, a former presidential candidate making the last of his 140 appearances at the Supreme Court. But his arguments had a familiar ring. Separate wasn't necessarily unequal. Blacks should be happy with the way things were. Didn't states have the right to educate their children as they saw fit? When the 3 days of arguments were over, Davis was heard to remark, "I think we've got it won, 5-4, or maybe 6-3. The justices scheduled another hearing on the case. But before that could happen, Chief Justice Vincent died of a heart attack. President Eisenhower chose to nominate Earl Warren, formerly the governor of California. On May 17, 1954, there were signs. Some of the justices' wives showed up. Some clerks were tipped off. Then reporters rushed the courtroom.
Warren starts off in a bland manner, and you can't tell for a while as he's delivering the opinion what the outcome is going to be. And then he comes to the key line and he says, "And we unanimously hold that separate but equal has no place in the Constitution." And it was just electric in the courtroom when he said unanimous.
We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we unanimously hold that the plaintiffs are deprived of the equal protection of the laws guaranteed by the 14th Amendment. Plessy v. Ferguson in education is no more, and in practice, Plessy v. Ferguson itself is no more. The era of Jim Crow, constitutionally speaking, is over.
This was precisely what we urged them, almost in that language. So it was gratifying to have the opinion come down almost in the language of the argument that we made to them.
In 1951, I'd used a plain geometry book that had been used by a white student in 1935. Brown said that that was over. The hand-me-down tubas that I played in the high school band from the white high schools, it said to me that that was ended. And it said to me that at some point, I would not have to travel from Atlanta to Greencastle in Indiana to get an undergraduate degree. That my family, my cousins, my neighbors could go to Georgia Tech and to the University of Georgia. The Supreme Court decision of 1954 was for me the Magna Carta. It was the second emancipation. It was a great moment.
Okay. So, getting back to the details surrounding Brown versus Board of Education, this takes place in the U.S. Supreme Court, right? The NAACP is aiding these groups to challenge laws that are segregationist or that are discriminatory, that are landing people in jail. Remember, it's kind of like Homer Plessy. Remember, he was on that street train, and he was told to move out of the whites only area, and so he got arrested, and he challenged that arrest all the way to the Supreme Court, and ultimately he lost. And the case Plessy v. Ferguson established that separate but equal was not an infringement of a person's constitutional rights. So that had opened the door to segregation and discrimination, because it said that it wasn't illegal, that it wasn't wrong, and it wasn't infringing on their constitutional rights. For almost 60 years, that had been the case. Let's see. Yes, for almost 60 years. It was in 96. This is 54. And when Brown versus Board of Education comes up, right, it's all of these cases sort of built into one. They're all challenging segregation laws. Thurgood Marshall is a name that you need to know as well. He's the lead attorney here. Later on, he's going to be the first African-American appointed to the U.S. Supreme Court, so that's something that you need to note. But in 1954, he is fighting on behalf of Brown, okay? And now, here's the tricky part, okay? Because you heard what Davis said, right? The other attorney, it's like, oh, blacks should be happy with what they get. And the attorneys for Brown know that it's not going to be enough to just say that this law is unfair or that separate was not equal. Instead, what they do in this case is they make use of psychology. Okay, so make sure you make a note of this. They make use of psychology. So how do they do it? Well, they individually had, they did this test, okay, where they individually had black and white children in a room, and they asked them to play with these dolls, right, and to pick the doll that they wanted. So they had little black dolls and little white dolls, and each child would come up and they kept picking the white dolls. And, little white child would pick the white doll and little black kid would pick the white doll. And when they asked him, why did you pick the white doll and not, why not the black doll? I mean, it looks like you. Why wouldn't you pick it? The children kept saying that they picked that doll because white was better. And what Marshall is going to argue here is that time after time, I mean, even from a very, very young age, these kids are taught that white is better. White gives them special privileges, that white is treated differently, and that the segregation laws, separate but equal, what it was a lesson in inferiority. That these kids are being taught from a young age. This law is teaching them that they mean less than the white kids. And that was something that was truly kind of undeniable. The argument was powerful. He teaches them, he talks about how this law is teaching them about their inferiority and about the superiority of the other group. And that in itself should be unconstitutional because it's damaging their hearts and their minds. It's doing long-term damage to them. And so when you see in that video, that they come out and they overturn Plessy v. Ferguson, and the language, right, that they use is really kind of special because it was unanimously, they agreed unanimously that separate but equal was inherently unequal. Okay, so it officially overturns Plessy v. Ferguson, which is fantastic. However, it doesn't do it overnight. Now, there is some language in the decision that is kind of vague. For example, the justices say that they should overturn these laws with all deliberate speed. Right? I have that highlighted. Well, not highlighted, but I have that written there for you. It's there for a reason. Okay? Because with all deliberate speed could mean anything. Like, what does that mean? Right? If you intend on doing it right away, then you are going to do it immediately. Okay? But what if you don't like this decision? What if your intention is not to overturn Plessy v. Ferguson, it's not to integrate the schools, it's not to end segregation, then how quick is that speed gonna come, right? Like, there is no intent there to overturn it. So with all deliberate speed doesn't tell you when to do it. It doesn't say in 1 month or in 1 week or within 5 years. It doesn't say it at all. It's very vague. And this opens the door for some folks to continue dragging their foot on this issue. In some places, obviously in a lot of places, white folks are going to be outraged. And we're going to start to see the beginning of this massive resistance where people are going to create, white citizens councils and, all kinds of groups where they want to fight segregation all the way. It just creates all kinds of outrage. You have, in some places like the sheriff and the governors coming in, and what they want to do is they want to stop desegregation because they feel like they're losing control of their communities. Eisenhower himself doesn't even back this law, this decision by the courts. He says that the states are the ones that have a right to govern. And so it's just really damaging, right? There's this huge case. It manages to overturn Plessy v. Ferguson. The Supreme Court totally agrees. But there's going to be a lot of resistance. Okay? White citizens councils, like I said, they're going to fight this all the way. And a year later, Emmett Till is going to be murdered. So that's really kind of like where the civil rights movement begins to pick up a lot of speed. And so that's going to be the next topic of discussion for our lectures.